Good day. This is the Ask Canada Immigration Lawyer podcast. This is Evelyn Ackah speaking. Thanks so much for joining us. I have the pleasure today of welcoming my colleague, Sarah O'Keefe, to joining us on our podcast to talk about her expertise as a wills and estates lawyer here in Canada. Welcome, Sarah.
Lovely. Thank you so much, Evelyn. It's a pleasure to be here.
Well, I'm really happy to have you here because I feel like this is very informative for people who listen to our podcast. I usually talk a lot about immigration and then all of the other areas that connect to immigration. And wills and estates is definitely one of them. So do you want to give us a quick overview kind of about your background and what brought you into this area of wills and estates?
Yeah, absolutely. I started out actually, my first articling position was in a wills and estates firm. They actually practice in corporate tax and estate planning, but that's kind of where I started. I had a genuine interest in helping people kind of put together these really heavy documents that are basically you're planning out your life and your death. So that's kind of where I started with that. And I've tried to kind of get away from it, but I keep coming back to this area because it's an area of law that everyone kind of, lawyers included, we don't take it seriously. We think it's just a will, but it's actually not. That is the bare minimum that you can do. So that's kind of why I find myself, as a lawyer, if I go somewhere else, I keep coming back to this because it's so important for everyone, historical Canadians, new Canadians, people who aren't quite Canadian yet. They're in a permanent residency stage. But when you're here, you need to have these documents. And I'm interested in getting that word out to make sure that everyone understands that these aren't just simple documents.
Absolutely.
They're outlining your life and your passing almost.
Absolutely. No, it sounds heavy in the sense of, oh my God, we're talking about when I'm not around, but there's so much more to that. So one of the things I'd like to kind of start the conversation around is, why do you think a will and more importantly, more detailed, an estates plan necessary for obviously our listeners and our clients would be new permanent residents, immigrants, new immigrants, and people who are even here for 3 to 5 years with work permits. Why is it important?
So from what I've seen, and for me personally, since I've been in this industry now, working in it for 5 years, everyone I've come into contact with, they have spent their lives building their estates. They work hard, especially people coming to Canada. You have worked really hard to get here. Sometimes it's a struggle to get here. And then when you get here, you want to make sure that you're protected. And if you don't put these documents in place, even if the will is not in place, the power of attorney and the healthcare directive, they function on your life. So if you come into Canada on day one, if something happens to you, which accidents happen, if you get into a car accident and you're incapacitated in a coma, you're basically having to either force your family members to get a court application to be able to take care of you, or you're almost having to let the cards fall where they may. So planning is important because why are we as people working so hard to build these estates for ourselves, for our children, these intergenerational wealth and legacy that we've created? Why do it if you're not going to protect it?
Absolutely. No, it's very powerful. I think you're totally right. You know, we all have stories of people who've come to Canada. I have one just off the top where it was so sad. It was a family that lived in Mexico, but the husband was Canadian and he'd been living in, Mexico with his family for 20 years and got sick and decided it was time to maybe move to Canada, came back to Canada, and within like a month of arriving, he died. And it was just like, and then I was getting these calls from lawyers and everybody to like, how can you help? And I was between the immigration for the child and the wife. And then on top of it, the will, which was a Mexican will. He didn't have a Canadian will. It was, but property in Canada. In cases like that, you just think, holy cow, this is so important.
It is. And then the hardest thing, it's so easy to put it in place, but if you don't have it in place, if you need it, it is very, very difficult. And so your example there, having that Mexican will, it does work, but one, you have to get it translated because the Canadian courts won't look through it. And then 2, you have to go through those Canadian courts again. So you're having to hire a lawyer, which they're never cheap. Then you have to go to court, which is, again, never cheap. So you're almost having to backtrack. Whereas why backtrack when we can just put it in place day one, put that security there?
Okay, so let's talk about what exactly the basic estate planning documents are that you would recommend. So let's say I come to Canada, I'm a new worker, even from the US, and I'm here for 3 years on an expat assignment. What do you think I need to do first?
So if you come to Canada and you don't have any properties, but you have assets outside of that, so bank accounts, if you have Canadian bank accounts, you should have a will, right? So as soon as you have assets in another jurisdiction, in another country, have that country a will. But more importantly, if you don't, let's say you come here and you're just temporarily in the country, you're renting properties, you only have a temporary bank account, then I would say you can maybe put the will to the side, but do not forget the power of attorney, the healthcare directive. They are paramount and one of the nastiest court applications to get, because you can live your life without a will. And there are resolutions, there's the Intestacy Act that can step in to dictate how your estate's going to be divided, which that's not ideal, but there's something. But when you have a power of attorney, or you don't have a power of attorney and you don't have a healthcare directive, someone has to apply to court to be granted it, that ability to step into your shoes while you're incapacitated. And then the scope of that granted power of attorney, granted healthcare directive is very, very limited. I actually saw someone who was, because I've only said this story, but I've actually seen a power of attorney that was court granted because they didn't actually have one in place. And it was so restricting that it didn't actually provide as much benefit as it would have had it been appropriately set up so that it could facilitate the actual role.
Okay, interesting. So we're talking about, let's say though, somebody who comes in and buys a house, which sometimes people do, especially now the rules keep changing. So if you have status, you can buy a house, and they have a young child. What do they need?
All of them. They need all of them. They need all of them. Because just think of it, even if you didn't have the house, if you just have a child, just a child, you want to talk about guardianship. You want to talk about where the estate is going. Because again, if you don't have the will, some of it's going to your partner, if you have a partner, and then some of it's going to go to your children. So you could have, and that sounds fine possibly, but think of it. If you have minor children and you have a wife that could take, or a partner that could take everything, you may want the partner to have it all in trust until they're passed and then go to your children. But if you leave it up to fate or the system, your minor children could have these trusts that are only in place until they're 18, right? If I create a trust, I can create it so that at 25 we reassess, at 30 we think about it, but if it's court applied, 18 they have it, and that could be a lot of money. And I have learned from very senior lawyers who have been in this industry, and the common expression is money makes people funny.
I like
and that's
that.
wills and estates. Yeah,
I think it's true. So you're thinking that they would need a will, a power of attorney, healthcare directive, and guardianship documentation.
Well, the guardianship would be in the will, right?
Okay. Yeah.
So it's sorted. Then you're taken care of.
Okay, that's good. Oh my God. So why do you think when people come to Canada, they don't really think about this issue until it becomes a crisis? I mean, Canadians are also bad, as you say, but at least we know.
I was about to say. Yes, exactly. I'd love to say it's just new Canadians, but it's just everyone. And I genuinely believe the reason is no one wants to talk about death. And I remember when I first started this practice, I actually struggled being just talking about this. It's heavy. These are heavy topics. You're having to talk about where you're going in your life, because we're talking about estate documents. But when we start talking about an estate plan, that is not just a will, power of attorney, healthcare directive. A plan is when we're looking at, okay, this is where you are and this is where you want to be, A and B. And how do you get there? Then we're talking about tax strategies, investment strategies, charitable dispositions in the will to offset taxes on death, those little tiny things, all of that. And that's why it's important.
Wow. So what's the difference then, Sarah, between a testamentary versus an intestate estate?
So a testamentary versus an intestacy estate is essentially the difference between having a will, which is testamentary, and the intestacy is there's no will. So then we're following the legislation, which dictates how it's to be divided. But when you have a testamentary estate, that basically means that the estate is protected by the will, which is essentially the will is protected through the executor. So they become a trustee. They have a fiduciary obligation to the estate. So that is the primary difference between the two. One is essentially protected, and then one is essentially dictated by legislation how it's to be divided.
And so in terms of wills and estates, does it matter where people are living, which province they're living in? I mean, I know that we're in Alberta and you can do work here, but I understand you can also help with people from other provinces as well. Is that right?
Absolutely. Yeah. So lawyers have, every province has its own bit of legislation. So they have their own rules and requirements. For example, the healthcare directive, if you go to different provinces, they call it something different. And I actually don't know why, but they do. But regardless, they all have their own individual legislations. And more or less, the wills, the power of attorney, the advanced healthcare directives with the name change, they're all quite similar, but different sections. That being said, you know, if I had a client who was in Alberta, but they also had property in British Columbia, for example, because British Columbia has a different kind of probate requirement, I would probably have a will for British Columbia as well as Alberta. So that's where we start thinking about, it's not just the document during lifetime. We want to look at how does that document come to life? And if when it comes to life, it's overly complicated, so that Alberta will is going to have to dictate the British Columbia the assets. If it's too complicated when it comes to life, get rid of it. Let's implement those other wills, those other powers of attorneys, so that it's simplified. Because what I find is money makes people funny, but the reason why this area of law is so lucrative for lawyers is because this is such a heavy emotional moment for the people who are left behind. So the simpler you can make it, the more planning that you can have, then on your passing, your loved ones just have to focus on the grief. They don't need to look for, they don't need to find the will or hire a lawyer, because it's all of your bank accounts are listed, all of your assets are listed. It's dictated how you're going to handle it.
That's great. That's how it should be. Have you experienced when people, let's say, what if you have a will in one country and then you come to Canada and you have another will? Because most people might have had one in their home country, but didn't create one or set up one because they listened to you and got one in Canada. So in the case like that, which will, generally speaking, would be the one that dominates or trumps the other?
Well, it depends on the assets. They kind of dictate what's going on. And that's another reason why you plan, because a will can actually change jurisdiction if you don't plan it correctly. So going back to your point, if there's assets in Mexico and there's assets in Canada, then the will is going to go through the probate process in Mexico for those assets, and the Canadian will is going to go through for the Canadian assets. And that sounds, a lot of people might hear this and they say, well, sounds like you're trying to make work for us to pay you. But you will actually save money doing it that way, because there's no dispute. There's no translation. There's less court applications. So that's how I would always handle it, because the will can change jurisdictions on its own even.
I like that message around obviously having a will and the impact of having an estate plan, not just a will, but an estate plan, how it actually leads to saving you money down the line, and especially saving your dependents down the line, because you put all of the elements in place. and you're not in court and you're not fighting and you're not going through all of that. So it's actually something that I think is about, you know, being economical, because by doing it right and getting it done, you're going to save money down the line. Generational wealth will just disappear into the tax man if you don't plan ahead, right?
Yes, and no one wants that. They get enough. That's how I feel. So even if you do that level of planning to avoid paying a bunch of taxes to the Canadian government, that's reason in of itself. But here's a good little story about how even if you have a will, if it's not thought out of how it functions, it's not going to be good. Because let's say you just say, look, all of my estate is going to go divided amongst my children, my personal assets divided amongst my children. I have 3 children. That sounds nice and simple, right? But when I see language like that, I'm saying, okay, which of the 3 children gets to pick first? Because the first person is probably going to pick the most expensive item, right?
Yes.
And as soon as that person picks the Ferrari or the piece of artwork that mom and dad loved, they're now gone, they're all going to fight about it, right? All 3 of them now are going to fight about that very expensive item. Or another classic is a memorable, a heartfelt item.
Yeah, sentimental. Yeah.
Sentimental. Yes, thank you.
Yeah.
That's exactly, those are the 2. So
wow.
planning the language of a document is vital.
Vital. Okay.
Yeah.
So I know that you don't do a lot of this, but estate litigation, have you seen some common litigation disputes? Is it a lot of what you just described, like family members at the end are fighting over assets? And I mean, it must be devastating to break up a family over money and, you know, what's left for them.
Oh, I have seen it. I've seen families in my practice where, again, it's always on the last to die as well. The first to die, that just goes right. Usually it's just rolled over to the spouse, surviving spouse. But when the last to die hits, usually the last to die never updates their will. So there's will discrepancies.
God.
That is classic. 2, sometimes when the surviving spouse has been surviving for a few years, they could meet a new person. And that new person, especially here in Alberta, there's the Adult Interdependent Partnership Act.
Yeah.
That's family law. So when you're doing your will, you actually have to be cognizant of family law as well, because on your death, that does not excuse you from those obligations. For example, spousal support, child support. And if you don't include that, we're now fighting about it in court, and you're probably not going to win. Another fantastic example is just liquidity problems. So I do see in my practice, I've seen common, I call them civilian solutions almost. It's just tricks that civilians use to either avoid probate, what they understand as probate, which is the process of going to court to finalize that will.
Yeah.
Or they're just trying to avoid hiring a lawyer at all because we don't have a good reputation. So what happens there is they're either going to move bank accounts so that the children are on the bank account with the parent, or they're going to put the child on the house so that on passing it doesn't go through probate. So even those 2 examples, that's a reason for litigation. Because I had a client and I wasn't in the role as litigation. I wasn't their lawyer for that. I was just giving her advice on, you need to be careful because mom put her on the bank account, which is completely fine. She helps mom a lot, pays her bank bills, her phone bills, etc. But she had other children. Those children weren't on that bank account. And I told the daughter that was on the bank account, I said, be very careful of this because that is not your money at all. And there's actually case law created because there's so many children thinking that on passing, that's now my money. That was what was intended.
Yeah.
And the other children are saying, no, you were helping mom. And it's been brought back to the estate on a resulting trust. So there's a lot of like heavy little tiny details that people try to avoid lawyers and probate. But in the end, you're coming back to court and you're dealing with lawyers because it didn't work.
And
the
it costs
document.
you so much more. I mean, like we see these wills at like the drugstore, people just put them together. Give me your
Oh,
sense of those, because, I
oh,
know that for lawyers, immigration lawyers, this whole concept of, even like legal Zoom and all this, everybody becomes an expert. What is
yes.
it like in terms of, people that you see purchasing those wills and what the impact is? It's not worth saving money to do it
No,
wrong.
exactly. So let's say, for example, like first off, let's say you have someone who gets one of these will kits and they've done their research. And I've met those people.
Mhm.
They're very smart. You don't need a law degree to kind of digest information. And they're really on it. They know what they're talking about.
Mhm.
But they aren't aware again of how the document comes into life. They can say, yes, I want Johnny, my son, to be my executor. I want all three children to be splitting the residue. I want some so and so going to my grandchildren. They can list it all out.
Yeah.
But if they're not thinking about how the document comes into being, it could
Mm.
still kind of not work out the way that they intended to,
Mhm. Mhm. And
essentially.
then it's all for nothing. I mean, like, I'm sure there've been lots of
Yeah.
litigation around these will kits, for everything from
Yes.
was there knowledge? You didn't get legal advice. Did you know what you were
Yes.
signing when you gave this to that person, or
Yes.
money going to a charity and not the kids? Like, I've seen some of those interesting cases where kids and,
Yeah.
those left behind are fighting because the
I've
person who passed made a decision to donate everything to the normal, to the dog
yeah. Yeah.
store down the line, or the kennel or whatever. Like, it's crazy, or the
It
charity.
is. It
Yeah.
is absolutely. And honestly, with every time, like lawyers, we have to go to we have to do continuing education
Yes.
courses. So
Yes.
every year I'm registered in wills and estates, in Alberta and
Yeah.
in Newfoundland and British Columbia. And that is one of the common, and I'm not saying in a bad way, but it's one of the things lawyers are really excited to see what is this going to become, because these will kits, they are a bit of a joke. It's almost like when you have to me, it's like you have a gaping wound and you put a bandage on it and you're like, that's good. The gaping wound is going to fester. You're probably going to lose a limb in the end of it all. It's not going to go well for you. But if you think of it, Evelyn, it's not just the will kits that I want to, talk
Mm.
about either. It's sometimes you have law firms that, and this is again something we've talked about in these
Yeah.
seminars throughout the provinces, but you have lawyers that like to dabble in this area.
Yes.
It's one of their favorite things to do is do this on the side. So you have, and I'm sure people know of it. You go, you reach out to the lawyer, they give you a flat rate fee, and they send you this attachment that says, okay, list all of your information and what you want in your will. And then the
Mhm.
lawyer drafts it, and then you sign it, and off you go into the good night. And that's
Mm.
it. That is usually just as well you did nothing.
Yeah, that's
More
the
often than not.
minimum.
Exactly. Because if we're not talking about who are you naming as an executor, right? Who are you naming as the power of attorney?
Yeah.
Are they the same people? Can you show me the real property report so that I can see the title on it? Because if it actually isn't held the way that you're telling me it's held, which usually it isn't, right?
Mm-mm.
Because who knows that when they buy a house 25 years ago? If it's not like that, the will again is not going to function the way it should. So
Unbelievable.
yeah,
Unbelievable. This is
it's
very much like, oh my God, everybody should have one when they arrive. The thing
it's
that
always
I'm really
scary.
interested in is the piece on guardianship and
Yeah,
our attorney. And I know that I guess April 16th is Advanced Healthcare
it is.
Directive Day in Canada. So can you talk to me a little bit about what is an Advanced Healthcare Directive?
Yeah, absolutely. So the Advanced Healthcare Directive is basically the other side of the coin of a power of attorney. These two documents step in during your lifetime
Mhm.
while you are incapacitated. So you are in a car accident, you're in a coma. The power of attorney takes care of your finances, and the Advanced Healthcare Directive, the health directive, takes care of your healthcare matters,
Mhm. Mhm.
right? And these two documents, even although they function together, they can have different languages. And the legislation that backs these documents gives you protection, because I always tell people when I'm looking at them, they scare people. These are the two scariest documents because they lift out all of the powers that you're giving to someone else while you're still alive. You have to really understand the powers that you're giving to these people. So the healthcare directive, you know, if I named my spouse, I get into a coma, my spouse can pull the plug whenever they want, as long as it's, you know, the language that's provided in there. But they're the ones who are, he's going to dictate where I'm staying, who I associate with, what programs I register in. So they are very, very restricting documents.
Yeah.
And I actually saw, and I apologize if this is not the focus of the health directive, but I did see one time I had an emergency, someone did an emergency power of attorney advanced healthcare directive. And when the other son came back to us to review them, because we were the original drafters, and he just wanted us to look at them, I reviewed the power of attorney and the healthcare directive, and the healthcare directive was as normal. It was very much, you know, take care of this person, have their best interests at heart. You know, if the focus is money versus health, health is always paramount. These are the requirements of, you know, what I want done, my donation wise. And then the power of attorney actually had very, very different language. It didn't have the fiduciary duty requirement in there.
Wow.
So you could almost do whatever you wanted with that estate. So another thing that you see traditional powers of attorney and healthcare directives, because they work together, usually if a healthcare directive is enacted, the power of attorney is also enacted.
Yes, you think so.
Right? You think so, normally. The power of attorney would normally have language that says, if these two people, because they can be two people in these two different roles, have a disagreement. So let's say mom's in coma, daughter says, mom needs to go to a care home. Son says, that care home is very expensive. Let's go to a little less expensive one. If they disagree, the daughter wins because the health is paramount. That is primary. But you can see directives, powers of attorneys, where the appropriate language that protects the health over the finance is not there. So
oh my God.
They're very important. And like I said, you can, the scariest part about the health directive and the power of attorney is that, you know, at least with a will, you're dead, I guess. You know, for me, there's, you know, the children are fighting, I'm just going to roll in my grave. But you can come out of a coma, and a lot of people do. And there is case law that talks about how, and I've had them, I've been a part of them, where they appointed a niece, and that niece actually, during that incapacity, wiped the entire estate out financially. And that individual, that example I provided is a real person I met last year.
Wow.
And she's now had to hire a lawyer to go sue the niece to hopefully get back what was stolen.
Unbelievable.
But that's what these documents can do.
Yeah, no, and I think for me, as even as a parent, so, you know, when I became a parent, immediately was getting the guardianship. And then at some point, you know, then I got married because my kids were adopted. And then it became, oh, we got to change this again, right? Because there were other people that were guardians. And so I think of wills and estates and all these documents that are connected. They're living in the sense that you have to update them. You get married, you get divorced, you buy a house, you know, like there are times when they need to be updated, right? How frequently would you say something like that, or just when there's a significant change in your life?
So usually it's the latter. It's this, when there's a significant change, you know, you purchase or you sell a house, an asset, you gain a child, even if there is a, you know, a loss in the family, that's sometimes, you know, an executor passed who you had named. But to be safe, because sometimes when I say big events, a big event is very, very relative. It's subjective to the person. So I've abandoned that logic. I say every 5 years, pull out your death documents, your incapacity documents, and just sit down and go through it. And it sounds daunting, but you will save time, money, stress, and aggravation.
Right.
The other thing I really recommend, and this is something that I find is always lost on firms that aren't focused in this area, is that the documents are very hush hush. They have a will, they have a power of attorney, they have the advanced healthcare directive, and nobody knows
Who
about them.
knows? Yeah.
Nobody knows they're appointed. Nobody knows the roles. No, they haven't seen the advanced healthcare directives. And in Alberta, the people you name don't have to accept the appointment,
Oh my
right? So
God.
there's nothing that they don't have to sign anything. Whereas in British Columbia and Newfoundland, they at least have to sign saying, yes, I'm consenting to this role. But if you don't even give them the knowledge, so I tell people, and I have found only success with this, family meetings
Yes.
are vital. Have the conversation about what your documents look like. You don't need to tell your children or whoever the beneficiaries are your net worth.
Yeah.
We don't want anyone sleeping with one eye open for the rest of their lives, which is how people feel. But you need to say, okay, if you put in trust for your children, explain what a trust is. Because I put them in place to protect the children. But if we don't talk about it, the children look at it and they immediately think, mom and dad didn't trust me. Why is my stuff not in trust? And usually it has nothing to do with the child. Yeah. But we're talking about a trust protects against matrimonial breakdowns of the children, of yourself, of spouses even. It can protect against creditors. It can protect against the government if you kind of get into any kind of bankruptcy issues. Like it is very, very, it's a useful strategy for estate planning, but something that is so useful is always interpreted, and I don't know why, as mistrust. So
that's so interesting. I've never heard that before. Well, this has been so interesting, Sarah. I really appreciate it. I mean, obviously you're a wealth of knowledge, and we're looking forward to being able to collaborate and help our immigration clients really make sure that as a part of their post-arrival supports, they consider wills. And so as you know, we're going to be writing about it, and you're going to be writing about it and talking about it and sharing this information, because I really feel like just like getting a driver's license and you buy a house and SIM card, everything, you need to think about changing your wills when you come to another country.
Absolutely. I wish they could put it in place so that everybody had to be forced to do it, like your driver's license, because that would make my job easier. But
it would.
Then again, the estate litigators wouldn't like it though.
What about things like, just as we wrap up, what about things like saying, you know, like organ donation? Do you put that in your, because a lot of times people don't know unless you tell your family. Is that something you would also put in your directive?
Absolutely. Yeah. This is where that advanced healthcare directive is where we're talking about if you want to do organ donation during your incapacity. So this is an interesting one as well. But so I apologize if it's not quite answering your question, but like if you say, like, let's say you are in a coma, or I'm in a coma. Let's make it nice and easy. I'm in a coma and my niece needs a bone marrow transplant. Now, if I just have nothing in place and I'm a match with my niece, I'm in a coma. There's nothing I can do about it. Right? That's it. If I'm in a coma and my advanced healthcare document directive has language that says, look, I'm okay to donate to my immediate family or my extended family, as long as it doesn't impact my life, then that would actually facilitate me being able to donate something that I would normally donate anyways to my niece, a bone marrow. But it lets you do things like that. So that's where that advanced healthcare directive, that's where we're going to get into what do you want? How alive do you want to be forever? A lot of people are focusing on a quality of life, not necessarily a quantity, but everyone is subjective. If you have religious rights and matters, this is where we can put language in there that says, you know, what you are okay with doing in the hospital setting and what you're not okay with. And actually I'll tie that into the will, because I do find that when I have helped Canadians or new Canadians in this area, a thing that gets missed is that if you have specific kind of rituals or religious aspects that you want to have abided, then that's something that we would put in the will as well.
Of course.
So I always think that's important. And the more you know, the more you can put in a document. That's what these are doing. The Advanced Healthcare Directive, power of attorney, the will, it's giving all details so that the person that you're appointing doesn't have to guess.
I know that would be such a that's a gift, I think, too, because it tells people what you wanted. You're not making decisions not knowing, especially like even the ceremony or the funeral rites or however, you know, what you wanted. And I think that's really great. So I really hope that this has been useful for people, because it's been very informative for me, Sarah. And I really appreciate you joining us on the Ask Canada Immigration Lawyer podcast. And people need to know, if they'd like to learn more about your services, they can contact us at Ackah Business Immigration Law. We'll be happy to connect you with Sarah, and she can talk to you about whether or not she can assist you with putting together a wills and estates package. If you're here in BC, Alberta, BC, or Newfoundland, right? Or even across the country.
Exactly. The Law Society has 100 hours. So again, it's just legislation. So to me, we can help every Canadian, new Canadian, historical Canadian, all of them. You need these documents.
We do. Thank you so much for joining us. It's been such a pleasure. Okay.
Absolutely.
Thanks so much for joining us on the Ask Canada Immigration Lawyer podcast. I hope that you will share this podcast with your friends and family. Please sign up, and please do give us a 5-star Google review so more people can find us on all the platforms where you find podcasts. Take care, everyone. Till next time. Bye-bye.